Implied condition. Kindly, before we start to navigate the topic, remember to subscribe our channel in order not to miss any video which we might upload in future. Introduction. These are terms of greater importance in a contract of sale of good act, breach of which amount to total repudiation of a contract. So, implied condition, they are terms of greater importance in a contract of sale of good, which breach of which might amount to total repudiation of a contract. So, breach of any implied condition result to total repudiation of a contract. The remedy for breach of implied term of condition is recorded under the Sale of Good Act, providing the remedy to is repudiation of the contractual relationship. Note that, however, the buyer may decide to waive the breach of implied condition as the breach of warranty, hence seeking remedy in terms of damage rather than liquidating the whole contract. This is referred to as the waiver of condition. So the waiver of condition is where the buyer may be lenient to the seller or the dealer or the manufacturer by evading to treat the breach of implied condition as the breach of by liquidating the whole contract, but treating it as breach of warranty, therefore requesting for damage rather than liquidating the contract in totality. Some of implied condition are the right to sell. The seller is entitled to sell good in both the agreement to sell and the actual sale, since he have the right to pass. If good turn out to be defective or pass in bad title, then buyer can sue the seller and liquidate the contract altogether. So the seller is mandated with the responsibility to sell good, either in agreement to sell or in actual sale. But if the goods are transferred in bad title, the buyer can sue the seller and liquidate the contract in totality. For instance, in a case between Roland versus Devar, the plaintiff bought a car from a defendant and used it for 4 months before discovering that the car never belonged to the defendant. The plaintiff had to return the car to the real owner. It was held that the defendant was in breach of above implied condition, and the plaintiff was entitled to recover the price he had paid for total failure of consideration or transfer of bad title. Sale of good by description. If the seller sells good by description, the described good creates an implied condition that the good should correspond. The good which will be delivered to the buyer must correspond with the described good. Failure to that, it can render the contract liquidated. This was covered by the case between Barry versus Whip. The plaintiff sold a reaping machine to the defendant, which the defendant had not seen. The machine was described to be new in the previous year, and as having been used to clear out 50 to 60 acres. On delivery, the machine was discovered to be much older and did not correspond with the one in the description. It was taken that the defendant was not liable to pay for the machine as it did not meet the description given by the plaintiff. So this case involved Barry and Whip, where the plaintiff was claiming for payment from the defendant after selling him a reaping machine, which the defendant had rejected, since it did not correspond with that one in the described 1 year ago. Condition to merchantability. The condition is provided under Section 6 subsection B of the Sale of Good Act, which provides that goods which are sold by seller should be of merchantable quality and fitness. It does not apply where the seller ought to have discovered the defect of good for examining, but if the buyer could not identify the defect in the good, he can sue the seller and compel him for the liability. This one is covered between the case between Mereri versus Fitch and Gibbon. Moreri bought a bottle of ginger wine from the defendant's shop. When he was trying to open the bottle, the neck came out and injured his hand. It was held that the plaintiff was entitled to the damage as the bottle was not of merchantable quality. So merchantable quality is key in implied condition. Another implied condition is sale by description. It is sale where the seller gets into an implied condition with the buyer. by offering a buyer a sample of good corresponding with the good he wants to purchase. Liability is excluded if the buyer could identify the good while examining the sample. So if the buyer could identify the defect in the good while examining the sample, the seller may avoid the liability. Or if the seller was given an adequate chance to compare the sample good with the good in bulk, the case was covered through the case between Donnet and Finas versus Boaz and Sons. The plaintiff went to the defendant warehouse to purchase some glue. The glue was stored in bales, and every facility was offered to the defendant to satisfy himself of the quality. He merely looked to the bills, but did not open any of them. On the delivery, the glue turned out to be of wrong kind. It was held therefore that there was no breach of implied condition because the plaintiff was given a chance to examine the goods. So this involved the plaintiff who went to the defendant house to purchase some glue. He was given the sample of the glues stored in barrels, stored in bales, and he was able to assess them, but he ignored to assess the good in bulk. So when they were delivered to him, he identified that the good did not correspond with the sample. It was held that he had the chance to confirm the bills with the sample given. So the court took that there was no breach of implied condition. Thank you for watching. Kindly remember to subscribe in order not to miss our future videos. Thank you.